information, Lisa, are you going to feed a gallery view to the live stream, or are you going to feed a speaker view to the live stream?
It should be what we're seeing right now.
I think that'd be fine.
Okay. The 5th District Court of Appeals in Dallas, Texas is now in session. Justice David Bridges presiding.
Today is April 14th of 2020, and this is the first video Zoom oral argument held by the court. The justices present are Justice David Evans and Justice Bill Peterson. The clerk of the court who is hosting this event for us is Lisa Matz. There will be 3 justices and 2 attorneys on your screen, plus a timing system. We are trying to do this as much as we can, like we would an oral argument before the court. You will have 20 minutes per side originally, with a 3-minute rebuttal, and for a 3-minute warning. And for rebuttal, you'll have 5 minutes with a 1-minute warning. If I usually do not inform the participants if the clock is going down or it hits that 3-minute mark, but because we're working through this process, I will today. The only interruptions for the participants as they speak will be the justices when they have a question. Before we get started, is there any questions that the appellant has of this process?
No, Your Honor.
Okay. Is there any questions from the appellee?
No, Your Honor.
Okay. Is there any concerns y'all have with us doing the Zoom today from the appellant or appellee? Appellant?
No, Your Honor.
Appellee?
There is
Okay.
not.
Okay. There's always a possibility that there will be a glitch of some kind during this process. If someone disappears from the screen, we will try to hold that, stop the clock to get that person back into the process before we continue. We can make no guarantees that everything will run as smoothly as we hope, but we think it will. So I now will call the case. The case is styled 05-19-01134-CP in the Court of Appeals for the 5th District of Texas at Dallas. David Hanschen, trustee of the David Hanschen Heritage Trust II and trustee of the Argus Stamp Company MPT, Michael Hanschen and Ryan Hanschen, appellants, versus James Hanschen individually and in his capacity as trustee of the Beer Son Property Trust et al. Now, I know that you've raised 2 issues. I usually don't read these issues, but we are doing this a little different, and there are other people trying to hear this access to this hearing. The first issue is the trial court's incorrectly granted a special appearance where the defendant was personally served with a citation and petition while he was physically present in Texas. And the second issue, the trial court failed to issue findings of fact and conclusions of law, despite appellant's request, and thus appellee is not entitled to presumptions to support the August 29th order. Appellant, you may begin.
May it please the court, counsel, members of the panel. As Justice Bridges just correctly noted, the issue here is that the trial court incorrectly granted appellee James Hanschen's special appearance because he was personally served with a citation and petition while physically present in the state of Texas. Both U.S. Supreme Court and this court's precedent mandate reversal. Accordingly, the appellants request that this court reverse and render a decision denying the special appearance in its entirety and remand it back to the trial court solely to proceed on the merits of the underlying litigation. To that end, personal jurisdiction attaches to a non-resident defendant when 2 factors are present. First, that the defendant's contacts with the forum state are purposeful. Here, it's undisputed that James Hanschen flew to Dallas, Texas voluntarily. And 2, that the exercise of jurisdiction is consistent with federal and state constitutional guarantees of due process. Importantly, this court has already found in the 2006 Stallworth case that an assertion of personal jurisdiction based on physical presence alone constitutes that constitutional guarantee of due process. the court may recall from the pleading or from the briefing, the facts of this case are relatively straightforward. In March of 2019, appellants sued Appellee James Hanschen for his individual conduct as the trustee of the Progeny Educational Trust, as the former manager of 2 limited liability companies, and as a former general partner of a partnership. Appellants did not bring suit against the trust, against the partnership, or against those LLCs. In other words,
Let me ask you a question. We'll learn how to do this on Zoom. How is it that you sue a trust? How do you sue a trust?
Well, you would name the individual on behalf of the trust in a representative capacity, but that's not what happened here. And in fact,
How you named him here? You named James Hanschen as trustee of a certain trust that Justice Bridges just read the name of. It
was actually James Hanschen in his capacity as. So the liability here is against James Hanschen for his conduct acting in a capacity as trustee. And in the underlying litigation, the allegation was that the trust was disbanded. And so because the allegation is that the trust was disbanded, the trust actually doesn't exist. So the allegation is that James Hanschen's individual conduct is the basis for liability, that he misappropriated funds or failed to pay certain fees. And as a result, the allegations below is that the trust disbanded and does not exist. So as a result, we couldn't.
You did sue him as trustee in naming the trust. Also sued him personally. You also sued him as the former manager and or partner of various partnerships. We have held in 2015 in Deutsche Bank National Trust Company versus Kingman Holdings LLC. I'll give you the Westlaw site, 2015 Westlaw 6523712. 2015 Westlaw 6523712. We held that naming Deutsche Bank in the citation as Deutsche Bank as trustee did not constitute service on Deutsche Bank as trustee of the, and you have to read it. It's just like when Justice Bridges read the trustee indication here. Deutsche Bank National Trust Company as trustee of Morgan Stanley ABS Capital One Inc. Trust 206 NC5 Morgan Certificates Series 2006/NC5. That's the formal name of the trustee that was pled in the petition. Suing Deutsche Bank as trustee is not good enough. So you would agree here that the citation here did not, so to speak, tag your it. It did not serve James Hanschen as trustee.
I would, if I can clarify one point, and I think I will answer the question, is that the citation, and if you look at the clerk's record on page 16, the citation is James Hanschen individually and in his capacity as trustee. So, and the important distinction here and the distinction between Deutsche Bank and this case is that we are not trying to tag the trust. And we are not trying to, and this is one of the issues that I believe that Appellee confuses the case on. And this is also the distinction made in the Elizondo case, which is there is a difference between suing someone in an individual capacity and in a representative capacity. And the issue in Deutsche Bank, and the same issue that was in Elizondo, is that there, the attempt was to tag someone in their representative capacity. That's not what we have here. Here, what we have is someone being sued in their individual capacity. And so James Hanschen wears multiple hats, but those hats do not claim to represent anyone. And so
I've got the citation on a separate screen of mine, and it says, State of Texas to James Hanschen, wherever he may be found. That's who this citation is addressed to.
Yes.
It says nothing about any capacity for James Hanschen.
Well, I would point the court to Rule 99, Texas Rule Civil Procedure 99B, which addresses the form of a citation. And the only requirement among things that are not relevant here, but 7 and 8 require two things. One, that the citation name the parties, and two, that the citation identify identify the defendant and identify the parties. There's nothing that requires that those identities be identified in the upper left-hand corner. So if you have the citation up on your screen at Clerk's Record 16, you'll see that it says to James Hanschen, wherever he may be found, and then directly below that, it identifies the parties, David Hanschen, and identifies to James Hanschen, that it says against James Hanschen in his individual and in his capacity as.
So if you had 5 different defendants in this case, just assume John Smith, David Evans, whatever, and it says to James Hanschen, and then 4 paragraphs down, it says that the lawsuit has been filed against, and then it names everybody who's been sued. And that the James Hanschen citation is served on David Evans. Your theory is that's good enough.
No, because in your hypothetical, there would be 5 defendants. Here we don't have 5 defendants. Here we have 1 defendant. So to make the hypothetical more closely resembling this case, you would be suggesting, as I think Appellee is suggesting here, that you would need 5 citations to 1 person, but that's not what's required here.
Happens in lawsuits where you're suing somebody with multiple capacities. You do have to issue multiple citations. It's quite common.
If you are suing that person in a representative capacity.
And that's what I want to get back to, because you keep saying you don't want to get relief against the trust.
Correct.
But the default judgment granted your client an accounting.
That's right. So
James Hanschen had nothing to do with his trust. He's just a person who's walking down the street. You sue him, you issue a citation on him, and you think you have the ability to get a court to award an accounting of a trust when you didn't sue him in any capacity related to that trust?
Yes, and the reason for that is because in this case, James Hanschen is the only one who has control over the books and records of the trust. And because we alleged in the underlying litigation that the trust has been disbanded, James Hanschen, that trust does not exist. Therefore, the only person who is capable of having access to the books and records to do the accounting is James Hanschen. So this would be different if the trust were still a thriving, available trust. But here you have James Hanschen, and one of the allegations is his failure to do certain things in his individually in his capacity as trustee. So when the trust disbanded, James Hanschen is the only one who would be able to have control where a judgment would give the ability to get an accounting from James Hanschen.
Thank you.
Sure. And to that end, appellants sued James Hanschen for conduct committed as the trustee or former manager of various entities or former general partner. And that is an important distinction here, because appellants were trying to assert appellants are not trying to assert personal jurisdiction over the trust, the partnership, or the entities. So when James Hanschen personally came to Texas and was personally served, he was tagged with that personal jurisdiction. And again, this lawsuit is solely against that individual, James Hanschen, for his conduct in an individual capacity. Now, what's important for purposes of, at the very least, the trial court granted the special appearance in all capacities. The problem, of course, with that is that James Hanschen was unquestionably served. So even if we took the allegation that there had to be 5 citations, which we do not concede at all, but at the very least, he was served in an individual capacity, and therefore granting the special appearance was reversible error for that conduct, on that issue. So this court should reverse for no other reason than the granting of special appearance when someone is individually served goes against the Supreme Court precedent and this court's precedent in Stallworth. And frankly, from our perspective, the inquiry can end there. James Hanschen was the sole defendant and was sued for that conduct when he traveled to Dallas, Texas. And while he was here, he was personally served with the citation and petition. The trial court, however, granted that special appearance in all capacities. All of the cases cited in Appellee's response brief are irrelevant to the issues here because they involve factual scenarios where the defendant was an entity doing business outside of Texas or an individual who was not personally served. In this case, appellants did not sue any entities and are not trying to obtain personal jurisdiction through a long-arm statute. The Appellee cites the Hotel Partners case, and I believe, Justice Evans, this is the issue you raised, that when an agent arrives in Texas to represent his principal, only the principal is doing business in Texas. Again, that's not what we have here. There's not an attempt, we are not trying to use or to frustrate the corporate shield doctrine to bring in a principal because of the acts of an agent or vice versa. We are not trying to get jurisdiction over James Hanschen because of something that the entity did and vice versa. So therefore, the minimum contacts analysis does not apply in this case. One thing that Appellee continues to harp on in the briefing is the minimum contacts analysis and the long-arm statute. To avoid personal jurisdiction, however, the minimum contacts analysis does not apply here. For example, I would point the court to this court's precedent in Winsboro Auto Ventures, which is the 2018 case out of this court, which said specifically that it reflects the reality that the long-arm service is not needed to obtain service over a defendant who is physically present in the state. Texas courts have unquestionably adopted the holding in Burnham and are clear that a non-resident, merely by reason of his non-residence, is not exempt from the court's jurisdiction if he voluntarily comes to the state and is thus within the territorial limits of the jurisdiction. You can obtain due process through personal service. The rationale makes complete sense as well, because when someone comes to the state of Texas, they are taking advantages of the benefits and privileges of being in the state. Therefore, when they are personally served, they are subject to personal jurisdiction here. The second issue that was raised briefly and that was read at the beginning was the issue of the findings and conclusions. In this court, the trial court below entered an order granting the special appearance on all claims against all parties. Therefore, this is a direct appeal. So appellants filed a request for findings of fact and conclusions of law, as well as a notice of past due findings and past due conclusions of law. Appellee admits that this is a de novo review from the final judgment, and it's not an interlocutory appeal. Therefore, all evidence in the record that was available to the trial court is reviewable here by this court. And accordingly, there's no finding to support the trial court's grant of the special appearance. And Appellee is not entitled to any presumptions that would otherwise support that finding. And that comes right out of the BMC software case. Therefore, this court may properly consider all the factual statements and the evidence presented in the clerk's record. To the extent that this court declines to render a judgment denying the special appearance, then the court should remand back for entry of the findings and conclusions. We don't believe that's necessary. We think that the court has all the information it needs to render an order denying the special appearance in its entirety, and any remand should be solely for a determination on the merits of the underlying litigation. Unless there are any other questions, I will give my time back to the court, and we would respectfully request that the court reverse the trial court's decision and render a judgment denying Appellee's special appearance in its entirety. Thank you.
Bill, you have any questions? Justice Peterson, Justice Evans, any more questions?
Oh, thank you so much.
Okay, thank you. If Lisa, if you'll reset the clock. Appellee, you get your chance to approach the podium. We can't hear you.
There we go. Sorry, I think I had been on mute. May it please the court, counsel, and the panel. Justice Evans pointed to the issue succinctly when he noted that there are 5 defendants in this case. James R. Hanschen was sued individually as a trustee, as a managing partner, and as a managing member of 2 LLCs. There is no tag jurisdiction when there's in-state service of a corporate representative against those corporate capacities. The petition itself has one claim, a breach of fiduciary duty claim, which is expressly limited to any misconduct that occurred in a corporate capacity. A company can act in no other way than through a natural person, but the reason that we give that natural person a designated capacity is to indicate that he or she is acting on behalf of a company and not individually liable. Because the petition only alleges facts against the corporate capacities, there is no individual liability here. Either way, appellant was required to show personal jurisdiction over 5 capacities, only one of which has been satisfied. We don't dispute that Burnham shows that an in-state service over a natural person confers personal jurisdiction over that natural person. What we dispute is that then the natural person can do a tag jurisdiction over the corporate capacities. Because there's no individual liability in the claims that were sought, and there was no relief given to appellants against the individual, the court had every right to grant the special appearance in its entirety. Although the individual may have been served, he was not sued. And although the 4 corporate capacities were sued, they were not served. The Fifth Circuit has said that in-state service of a corporate representative does not confer personal jurisdiction over the corporate capacities without the minimum contact analysis. Appellant has conceded in its brief to this court that it cannot meet the traditional minimum contact analysis to establish general jurisdiction over the individual or over the corporate capacities because all are residents of the state of Washington. Appellant has tried to create specific jurisdiction by filing a declaration after the special appearance on a motion for reconsideration that was not heard to say that the meeting in Texas, which occurred after the lawsuit was filed, somehow is the contact for which specific jurisdiction can be attached. As the court knows, specific jurisdiction means the claims arise out of the contact. So it does not make sense for the contact to have occurred after the claims were filed. Without Burnham establishing personal jurisdiction over the corporate capacities, with appellant's concession that general jurisdiction does not exist over those capacities, and with specific jurisdiction not existing in any of the pleadings or in response to the special appearance, the trial court correctly granted the special appearance against Mr. Hanschen in all of his capacities.
Well, what do you do with the fact that they are desirous to hold James Hanschen personally, so he personally responds in money damages for what they allege to be wrongs in the handling of the trust and the entities that the trust was supposed to have set up and maintained?
Well, there isn't a claim against Mr. Hanschen in his individual capacity. The trust still exists and the LLCs still exist. And the affidavit attached to our special appearance from Mr. Hanschen establishes that there was the ability for appellants to sue those entities, but knowing that they couldn't get jurisdiction over them, they've attempted to only sue the individual in his various capacities and claim that he is somehow individually liable for actions that he only committed according to the petition in those specific capacities.
So let's deal with some basics. So you admit that they named him personally in the petition, right?
Yes.
And they have sued him for, and I think, like you are saying, they've sued others, but they've sued him for breach of fiduciary duty. And assume that they develop facts that he took $10 million out of this trust unlawfully and put it in his bank account, even if all that occurred up in Washington. And he shows up here in Texas for this meeting. He gets served with this citation, and they want a money judgment against him personally. They'd be happy to get one against everybody else that might have something to do with it, but they definitely want one against him personally. You don't think this petition and that service is good enough for them to proceed in Texas to explore whether it exists and whether they can get a judgment against him?
Correct, Your Honor. I don't think that the petition is good enough because the petition doesn't allege any individual claims. The allegations expressly in the petition for breach of fiduciary duty limit the claim to in his capacities, and they list as trustee, as managing member, and as managing partner. In the factual allegations itself of the claim, they are limited to his capacities. They don't claim that the individual had misconduct such that it would award monetary damages to them from the individual. That's not pled.
We'll roll the camera forward on a claim against where you name the trustee and you have two different types of claims. One of them says to the trustee in a lawsuit, you didn't follow the terms of the trust. I'm owed a little more money than you're paying me, so I need some more money. And where would that come from? It would come from the trust, right?
Yeah.
Okay. And then the other one says to the First National Bank, let's say hypothetically that used to exist of Dallas, Texas, you stole $10 million from the trust acting as trustee. You put it in your own accounts. I want a $10 million judgment against you. I don't want it coming out of the trust, which I hope will continue on in the future. That is personal liability of the bank as the trustee. And you're hoping that the money's going to come out of the bank's bank accounts. Why is that not what they're seeking here personally against James Hanschen?
Because, Your Honor, that's not what they've alleged. The petition doesn't allege that there was 10 million moved into James Hanschen individually's account. The petition only alleges that his misconduct was a misapplication of investments done by the company.
Well, that's a good point, but what they allege is that he personally did that wrong at acting as the trustee, and you don't think he could face personal liability for that?
I don't think he can face individual liability for that because in the special appearance, I attached the bylaws as well as the member agreements showing that he doesn't have individual liability unless he commits tortious conduct, which there has been no allegation that the individual committed tortious conduct. This is akin to saying that was a bad business decision when you were acting as the company. And because you made a bad business decision, I want to hold you individually liable. But as Your Honor is aware, when I act on behalf of the company, even if it's a bad business decision, that doesn't hold me individually liable for that conduct. It's the company's decision. I was just the decision maker because the company cannot act in no other way than through a natural person.
So it sounds like you're going to win on a judgment. He can appear and say those actions were taken. That, you know, those don't sound like jurisdictional arguments as much as they sound like merits arguments. Why am I wrong?
Because the corporate capacities were never served. So at this point, it is a jurisdictional argument because we don't have the capacities subject to the jurisdiction of Texas right now. Only the individual was served when he was in Texas, and there's not any cases that say personal service of a corporate representative while in Texas confers jurisdiction of those capacities. You still have to do a minimum contact analysis. And at this point, there's no general jurisdiction alleged. He actually conceded that it doesn't exist, and there's no allegations of specific jurisdiction over those corporate capacities.
So in other words, the corporations and that trust cannot be held liable for any decisions made by the Texas court, only David Hanschen.
Well, his recourse would be to either sue in Washington against those entities where they were organized, or in fact, the trustee is governed under the laws of Liechtenstein and an arbitration provision applies. So it's not as if Appellant is without recourse. It's just David.
Well, but he doesn't want recourse against the company. He doesn't want recourse against the trust. They want recourse against David Hanschen as an individual. You'd agree that this court properly has jurisdiction over David Hanschen as an individual. Is that true?
That's true. If there were claims brought against Mr. Hanschen as an individual, then service on him while he was in the state would confer jurisdiction over the natural person.
Do you dispute that this court has the trial court has jurisdiction over David?
I do not dispute that.
What do you do with counsel's argument that all of these entities, including the trust, have all disbanded, and their only ability to get any information, even about the entities, is to sue the person who was involved in running at least, I think, 3 entities, trust and 2 other investment entities? What do you say to that?
The facts in the record show that the companies and the trust are still in existence. There hasn't been any winding up of any of these companies. So there is an ability for appellant to bring in the entities or sue the entities because they do still exist.
Okay, thank you.
Unless there's any other questions, I'll give my time back to the court.
Thank you. Lisa, would you reset the clock? Appellant. One of the things I know that we should have done, and I don't know if you've done it each time, but would you state your name again and who you represent?
Yes. My name is Rusty O'Kane, and I represent the appellants in this matter.
Okay, thank you.
And I want to address a few things in particular that I think we've gotten too far afield into talking about. And Justice Peterson, you're 100% correct that this is not a question of whether or not we will be successful on the underlying merits or the liability issue. The issue is here whether or not you have sufficient contact, or whether or not personal service is sufficient to confer personal jurisdiction. We can fight over liability at a later time, but here the question is personal service, while someone is physically present in the state of Texas, sufficient to confer personal jurisdiction? U.S. Supreme Court precedent and this court's precedent say yes. Specifically, we don't, and I want to correct one thing. We do not have 5 defendants. We have 1 person sued for conduct committed in an individual capacity. And this is where I think the court and Justice Evans and Appellee have addressed the issue of the distinction that has to be made between someone acting in an individual capacity and someone acting in a representative capacity. And all of the cases that Appellee cites to, and this is the issue that came up in Elizondo, which is James Hanschen is not being sued for being a representative of. He is being sued, and Justice Evans, you mentioned this a moment ago when summarizing my argument, which is James Hanschen's conduct is the issue. And because he is being sued for what he personally did, acting in those various capacities, and the damage that he caused in those various capacities is what constitutes the underlying claim. So therefore, when James Hanschen came here, he did not, and I think we put this in our brief, James Hanschen does not leave his capacities in Washington. He doesn't get to pick and choose, hey, I'm coming here to Dallas, Texas in my individual capacity, but the other hat I wear is in Washington. That's not how that works. James Hanschen, the person, was sued for his conduct. James Hanschen, the person, came to Dallas, Texas. James Hanschen, the person, was sued or served with the petition and citation. The citation says specifically James Hanschen, wherever he may be found. In fact, the petition does allege that James Hanschen is being sued both individually and for his individual conduct in various capacities. So we're not here to discuss whether or not I will be successful in the underlying litigation. What we're here to discuss, and for this court to decide, is the sole issue of whether or not personal jurisdiction attaches, and then we can go fight over the liability question. But we do not need, and I don't believe that Rule 99B requires that 5 citations be issued and served on one person for that person's individual conduct. And I concede, Justice Evans, that if this were a suit against 5 defendants, we'd have a different issue. And or if he were being sued and trying to hold those corporate entities liable, or trying to get damages from the trust or get damages from the LLCs, we'd have a completely different issue. But here, appellants are only seeking damages from James Hanschen. And in fact, one of the issues in the case is that James Hanschen failed to, and this is alleged in the petition at Clerk's Record 11, where the allegation is that James failed to make certain payments. The beneficiaries or the appellants here are not trying to recover damages from the trust or the LLCs. They are trying to tag James Hanschen's bank accounts and seek damages arising from James Hanschen's conduct. So both the Stallworth case, the Burnham case, as well as Flores and Gonzalez cases all stand for the proposition that as long as the person comes to Texas and is personally served with the citation and petition while here, personal jurisdiction attaches. So that's why the trial court's decision was error, because the trial court granted a special appearance even though someone was personally served. The trial court, I believe, got to the question of liability, which is not even an issue yet. We can go through all of that at that time. But
Yeah,
for
30 seconds, sir.
Thank you. For purposes of this analysis, the sole question is, did personal jurisdiction attach to James Hanschen when he was sued, when he was served with the citation and petition? The answer is yes. So for the foregoing reasons and for the reasons that were cited in our briefing, we would respectfully request that this court reverse the trial court's decision and render a judgment denying the special appearance in its entirety.
Justice Evans, do you have any more questions?
I don't, thank you.
Justice Peterson, do you have any more questions?
No, I do not.
Okay, this case will be submitted on the briefs and argument of counsel. Thank you both for your willingness to step forward and hear this conference oral argument in difficult times. We thank you for your presence, and we thank you for your presentation today. That's the end of this conference. Thank you.
Thank you, Justice.